Well, hello everybody. My name is Melinda Plue. I am Director of Advocacy and Chapter Development for the ARC of North Carolina. And with me today is Kevin Kiser. And we thought we would have a conversation with you today about all things guardianship, or at least some things guardianship. I know that there are a lot of questions and confusion and misunderstanding and hesitation and some fear about the process, about everything involving guardianship. And we get a lot of questions, we get a lot of emails and calls to the ARC, both from people that don't understand the how-to side, as well as not fully understanding that we actually support a lot of families, a lot of people with disabilities in the state of North Carolina in guardianship. So Kevin and I thought we would have a conversation today. And full disclosure, not only am I a professional in this field with the ARC of North Carolina, but I'm also a family member and do provide guardianship. I serve as guardian for my brother-in-law, Jake. Kevin, why don't you introduce yourself?
Hi, Melinda. Happy to be with you today. My name is Kevin Kiser, and I am a regional guardianship specialist with the ARC of North Carolina's Triad region. And I've been with the ARC since 2015, working in guardianship.
Can I just first ask, what makes you so passionate about guardianship? Why is it important to do this work well?
I believe that we are working in our most vulnerable population that exists. When I think about the team that works with me, their priority and mine is to make sure that people who do not have families and have high needs have someone with them to help navigate very difficult systems and to work their way out of those systems and into less restrictive, more free environments. Our number one goal is to keep people from being institutionalized and try to lead them into choice and opportunity and lives in the community that work.
Just like people without disabilities, right?
Exactly,
Yeah.
exactly.
So when we're talking about this, why would somebody need a guardian, first of all, and why would somebody want to become a guardian for their family member that has a disability?
There are so many reasons that a person may need a guardian. And the way that people land in guardianship varies from county to county in North Carolina. That's up to the clerk's discretion. So as corporate guardians, we inherit most of the people that we support from DSS. Not all, but most. These are folks who don't have family, maybe don't have natural supports, or family is not supportive. They're in exploitative situations. A good number of the folks we serve are duly diagnosed with an intellectual disability and also some mental health challenges. Um, so DSS is one entity that does that work. We are a corporate guardian, another entity that does that work. And then you also have family. In a lot of cases, that's who is reaching out to us. And I think family members are absolutely in the best position to be guardian if they can do that in a way that's healthy for the whole family. But as corporate guardians, sometimes we provide just enough space to be that decision maker, make those tough decisions, and allow space for family to be family also. So that's another common scenario. But guardianship is not a role to take lightly. It's very involved, very complex, but we really enjoy the work that we do despite its challenges. And I can definitely understand where families would need lots of information. It is at times cryptic and difficult systems to navigate. And so that's part of the reason we're doing this advocacy work here is to offer some answers, some solutions.
Yeah, one of the things that I remember hearing early in my career here was guardianship is a status. Guardianship is not a service.
That's absolutely correct. If we were a service, we would be billing Medicaid and more in that systematic function. As it is now, we stand outside of that just as a legal status. And that also gives us the ability to coordinate all of those other services.
What um, what is the process for, say, I want to obtain guardianship for a vulnerable family member, or my child is turning of age. Can you walk me through what the process looks like? What kind of guardianship? What does that look like for a person?
If you've got a child who is a teenager and who is about to be an adult, generally people start that process at about age 17 and a half. There have been some changes to the law since 2024 that can extend the process a bit, so you may hedge on the side of a little more time. Um, Types of guardianship are guardian of the person, where you are just responsible for the care of the person and coordinating their safety and their needs to be met. General guardianship includes financial matters, and there are some extra requirements for general guardianship. That is not what we do at the ARC. We are guardian of the person only, but a lot of family members choose to be general guardian. There's also guardian of the estate that is used mainly when a person has more assets than just what's coming in from Social Security or Medicaid. And guardian of the state is primarily and only financially related.
So it can be confusing. I always remembered or tried to remember that there were three types. It was guardian of the state, so matters of money, guardian of the person, matters of health, decision making about where somebody lives, perhaps, and then putting those two things together would equal general guardianship. Is that still a fair, simplified way to explain that to people?
Definitely. That's right
Okay.
on the money.
Okay, all right. What about, I've started to hear a little bit about limited guardianship. What does that actually mean in North Carolina?
Limited guardianship is a fantastic option because even if a person is under full guardianship, they can always petition to have rights restored. And those can be very specific. It may be the need to have a driver's license. So you would petition to say, this person's able to drive, bring some evidence, they've gone to classes. This will be helpful to them in their work and their life. Um, if you only need protection from exploitation, that may be one thing that's outlined in limited guardianship. If you are entering guardianship for the first time and you know that this person is just going to need financial help, maybe some help with housing and medical, you can delineate those things with the clerk and it gets written into the order. So it can be an initial way to do a less restrictive setup, or it can be changed later to move towards less restrictive.
That's really good to know. In my situation, we're using limited guardianship as of late to help manage spending money so that the person that I support has access to his own spending money without having to go through the general guardian. So that makes a lot of sense to me.
That's a great adjustment, and think about how valuable that probably is to the
Oh,
supported person.
it's extremely valuable because, otherwise I would not have been able to get him a debit card or anything in his name, right, financially. So how else does somebody learn how to manage money except to practice by doing it
Right?
safely? That's great. Okay. Could we talk a little bit about the timing? So, if I'm a family that is considering guardianship or even limited guardianship for a family member that's turning 18, what does the timing look like other than it being about the age of 17 and a half? How long does the whole process kind of take for a family?
It's going to be case by case per county, but I think generally it's safe to say that when you petition, it's about 3 to 4 weeks before a hearing gets set up. Now, that can be longer in larger municipalities or shorter in outlying counties. It just depends on their workload. But generally, when a petition goes in, you've got a hearing within a month.
Within a month. That's great. Okay. A couple other questions as I'm talking this through you. If a person already had a driver's license and then is going through the incompetence process, and I want to talk about that word incompetence and ward with you in just a minute. Can they retain their driver's license from the jump if they are going through that proceeding?
They can, but again, that would be a limited guardianship situation. So if you petition for full guardianship and that's the way that the hearing goes, the privilege of driving would be removed. And there is a link between the court system and the DMV to functionally do that. However, you can go in initially and make that a limited guardianship, which includes the privilege to drive, as long as the clerk agrees with that.
As long as the clerk agrees with that. Okay. And is limited guardianship in North Carolina a common enough new concept that clerks are embracing it across the state? Do you feel like that's happening?
I would love to say it was being embraced across the state, but I don't know if we're at that stage yet. I do think there's still plenty of word to be spread about how effective that can be. It does require a bit more of the guardian too, right? So if you're full guardian, you know the scope of what you're doing and how you're helping that person, what you can and cannot do. With limited guardianship, then you've got a little extra detail to remember or ways to navigate that are going to include the person and the rights that they retained. It's going to be a little more collaborative when, if it's done well. Um, but it is starting to increase for sure. I think the changes in 2024 with the statute have made a big difference in how the guardian ad litems proceed, and those functions naturally cause more limited guardianships than were happening before that.
Well, I've noticed in working with families over the last 6 months that the forms, the forms from the NC court system have changed or been updated at least in the last year or two to specifically ask what other measures might be less restrictive than full guardianship. So this might be a good time to talk about, in our world, we talk about alternatives to guardianship and we talk about supported decision making, and we even talk about restoration. So I'd love for you to talk a little bit about those things to help give people an understanding of what they are and how it might be useful to their family member.
Yeah, your most common and honestly most effective tool is using a representative payee or a joint checking account. Um, Finances, as we can imagine, become a primary sticking point. So when you can set those aside and use a service to handle all of that, that can give families space enough to only focus on supports, not full guardianship. Um, I would say special needs trust, if you're able to do that, is an excellent route to go. You can do a healthcare power of attorney or a durable power of attorney. Those are also less restrictive alternatives. Um, Supported decision making is fantastic. It's probably the best and most effective and least restrictive setup if you are in a position to do that. Supported decision making is not um, a legally binding arrangement. It is truly gathering your natural supports. If a person, has abilities that work, they're in the community, and they've got helpful folks around them who are willing to sign on to a plan, it basically is that. Here is the plan for our person that we all care about and that we all want to support and that we want to retain their rights. Supportive decision making steps in instead of guardianship. And that is a written agreement, and you'll find on the ARC's website, or maybe you'll find on Rethinking Guardianship's website, some templates for supported decision making agreements. And it's really beautiful when it works. You do have to have good natural supports, but everybody signs on. The person who is being supported is the decision maker, and those around him or her are helping with facilitating, with making sure that that person has everything they need to make their own decisions,
Kind
basically.
of informed consent kind of thing, making sure they have all the information so they can make that decision.
Absolutely. Yeah.
How does that look in practice? If a family wanted to go that route, do they then need to put that particular template or document on file with different entities so that all the entities, doctors, banks are understanding if that's the arrangement? Or is it more informal than that?
I think basically that's the ideal version. It's a new enough concept that I do believe there's a heavy dose of informality with it, But yeah, that would be ideal if you can share with all involved what the arrangement is and who the parties are that are the trusted parties for the supported person.
Let's talk for just a minute about some of the really uncomfortable, ugly words that are used when we're talking about guardianship. The big one for me as a family member is incompetent. That word is all over the documents. The proceeding is called an incompetency hearing. Can you talk about that word and why it's still there, and maybe even the even uglier word ward, and kind of our work in that arena?
That is a challenge. There's so many examples of the euphemism treadmill, right? And this is a legal vocabulary that brings up connotations that are nothing but negative, and probably give all of us some preconceived ideas about what a ward of the state is or what an incompetent person is. When we talk about that, our team laughs out loud because we are very aware of how unbelievably capable the people we support are. Being under guardianship does in fact not mean that you are not able or that you are completely incapacitated. Sometimes it will, but the majority of the people we are working with have substantial abilities and have landed in a circumstance that has caused them to need this support. And I do know there are those around the state who are advocating for a change in that language, but for now, that is the legal lingo, and so it is still used because it is still in the statute.
I should point out that if you have the Arc of North Carolina as your guardian, we would never refer to that person as a ward. They're people supported. And when we are talking to families about the process, we usually try to caution them that the word is there. It's a trigger warning. It's there, but it has nothing to do with the potential or the capacity, really potential of the person that needs
You're
that.
right. And when we start working with people, one of the first things we hear often is, I am not incompetent. And we can honestly say to them, that is true. Literally, this is legal definition. And our goal is to work you out from under that and to make ways for you to not have that label.
Yeah. Well, and much like we have hopefully eradicated the mental retardation classification in medical and legal books, right? Textbooks and journals. Hopefully, we can shift into ward and incompetent into a little bit better language in the coming years. So that's advocacy work that we have to do at the ARC locally and nationally. So, um, can we talk about the differences maybe between a corporate guardian and what a family guardian is, and what they do and aren't able to do in their role?
That's a totally applicable topic. We get that question a lot when community members are calling in. Even when we are beginning work with a person as a corporate guardian and we're having contact with the family, um, we have to be clear about what we as corporate guardians are able to do, and that can look very different than what a family guardian will do. As you can imagine, we as corporate guardians are managing larger caseloads. We've got multiple people that we're working with. Time management becomes something that has to be monitored very carefully. We have criteria from the state that is set up by the Department of Aging and Adult Services, and we operate by that criteria, but very often are seeing our people interacting with our supported people way more than that criteria mandates. As a family guardian, it is going to be much more of an existing relationship. You're going to see much more of the person. Corporate guardians are going to be working more in the background with the providers, and then the providers and the family, we try to nurture those relationships as the corporate guardian. If in fact you are a family guardian, I think that time spent is just going to be much more increased. And
Mhm.
that's the reason the court prefers a family member over a corporate guardian or over DSS, a disinterested public agent. Families are always best when it can happen. Unfortunately, it can't happen for everyone.
Right, right. Well, if somebody were a family guardian and a change needed to be made because of critical illness or death of the guardian, what does the process look like in order to make a change like that? Is that something that I'm just going to want to put in my will who the next guardian should be, or is it much more formalized than that?
It can look different ways. If we were going to work with a family under a private contract, they would enter into their will their wishes, and then at the time of the change, whether it was incapacitation or death, those wishes would be implemented and they go into effect, and then the court processes start. So you're still going to land in a place where you're in front of the clerk, and the clerk does, in fact, have to agree to this prior arrangement. But
Mhm.
in almost every case, the clerk would agree to that because it's well organized and it accomplishes the support that's needed. And so you would still go through that petitioning and hearing process, but it would be initiated by the wishes of the family before the major life change happened.
Okay, okay. Does a person need to hire an attorney in order to do any of these things?
It's not necessary. We do not often use one in the work that we do. However, I do hear that there are some counties who really prefer having an attorney representing the person. You can know and be assured that a guardian ad litem will be appointed for anyone who is subject to guardianship, even potentially. And that guardian ad litem is different than a guardian ad litem who's a volunteer that would work with teens. This is a lawyer who represents the best interest of the person in that court hearing. And so they are going to prioritize that individual even over, the wishes of the corporation or the family or any interested party. They are there for the supported person to make sure that if they're going to go under guardianship, that it's warranted. And that's a great segue, honestly, into some of the changes that happened in 2024 because
Yeah.
the GALs, the guardian ad litems, they are now bound by that statute to discuss these less restrictive interventions, to attest to why those less restrictive options won't work. And if they attest to that and they feel that it's in the best interest of the person to go full guardianship, then that would be their recommendation. But it also creates lots of pathways to talk about how would this alternative work? How would this alternative work? And what's new is that conversation has to happen face to face now.
Mm,
So you may see a little extension of the timetable because there are more continued hearings if the GAL has not been able to find the person or be connected with the person for whatever reason. It may add a continuance or two to the process, but it's super valuable conversation to be had with the person who may be under guardianship and also with that family.
okay. And am I correct in that the guardian ad litem is really assigned at the moment of the filing for the hearing? Is that correct?
Yes, that's right. When the notification of hearing comes out, the guardian ad litem will be listed there.
Okay, okay. Maybe we could talk for just a minute about what are the responsibilities of a guardian. Maybe we'll start with what are the responsibilities of a family guardian if it's different than a corporate guardian. Although I would hope and assume that the responsibilities are similar.
I do think so. I think
Okay.
I think it'd be easy to discuss due to the similarities. Primarily safety, right? A lot of situations that lead somebody to guardianship um, require an adjustment to make sure that that person is safe, not being exploited, not being abused, um, assisting them in any processes needed, whether it be a 50B restraining order or any other court processes. A lot of times we're in criminal court with the people we support and helping them work through those systems. A lot of backup is what the guardian should bring to this person. Making sure that they are housed, that they have their basic needs met, making sure that they have the wraparound services that are needed for them. And that can be a challenge in this environment, as you know. There are a lot of holes in the systems that we work within. So we do our best to navigate those systems, get a great ring of support around that person, and be able to point them in the direction that they want to go, whether that's independence and restoration, whether that is a job, driving, marriage is something that a person can still do even while under guardianship. So, coordinating those services, keeping folks, and then absolutely working to just move towards less and less restrictive circumstances, whether that's in housing and socially, or whether we're talking limited guardianship and restoration, which is the ultimate guardianship move is to usher someone out from under guardianship. And that gets us excited. That's our goal as a team generally is to get there.
Oh, sure. Yeah, yeah. I heard you mention marriage. What are the rights that a person under guardianship still retains, even if they have a guardian?
They vary from state to state, but in North Carolina, the person retains the right to vote, which is fantastic. That is not true in every state. They retain the right to marry, but since they cannot file a civil petition, they're not able to file for a divorce. So that is an odd one. That's a little sticky. Um, they retain the right to privacy, to, of course, basic human rights. Things that do go away are the ability to have a driver's license unless you specify. I know they go on a registry that's weapon related. I think the NICS registry. So that's another piece to consider when a person is restored. Um, but those are the basic ones that stay.
I
You may
love that
have,
you still have the right to vote. It's
yes,
hard for me to imagine anybody losing the right to vote,
no.
but it's not, you're saying it's not in every state that's a given.
Yeah, that's right. I think Texas is one where that's not something that you can do. I have a great picture in my mind of an assisted living van when I was there visiting someone we support, loading up to go vote. The staff had taken anybody who wanted to go, and the folks who were on their way to vote were just excited to be participating, and it was
Absolutely.
lovely to see.
What would you say when it comes to daily decision making? I feel like I hear from a lot of families, and this does resonate with me as a family member, that people look at guardianship as a way to protect their loved one from making the same decisions in their youth that we kind of made in ours, right? Decisions that parents might not agree with. What do you say to parents that think and hope that gaining guardianship will help them make decisions that keep their loved ones safe?
It is an obvious and admirable goal. I will say that's going to look very different if you are a family guardian versus a corporate guardian. Um, as a corporate guardian, a part of the benefit of that is the space between. And so I would say that there's no part of guardianship that allows or gives you tools to make anyone do anything. It is certainly not a situation where control is the main tool. It is 100% relationship based, and thank goodness it is. That's also what makes it fun. We have no stick. We are not the authorities. We are your help. And I think even if you're a family guardian, that is the most expeditious approach to helping the person get to where they want to be. But what comes with that is some risk, right? The same way we all had risk. One of my favorite concepts that the ARC espouses is dignity of risk. I love it. I love that our people are considered in such a whole person way that even though there's some liability, even though there's some family fear or some corporate liability, the value is there in allowing people to make their decisions. We inform, we give them all the information we can and show them what these supports would mean, what this choice would mean, but they choose it. Guardianship done well is the person making choices with support. certainly not the guardian making choices for the person.
It makes me smile because it's not different than raising our own children and getting them to adulthood, right? And hoping that we can help them make decisions that are smart and safe all the time. But guess what? They get to make their own, whether we like them or not sometimes. Um, with Jake, my brother-in-law, who lives on his own in his community, I am often questioned in a very loving way that he's alone and unsupervised, right? Or that he's been drinking beer. And I laugh, and it's a great opportunity to say, he gets to make those decisions. He's a grown man, just like the other grown folks around here. They get to make those decisions if they choose to. Dignity of risk is such a great thing to be able to explain to people about the value of people with disabilities.
I
And
completely agree. And I
yeah,
think that's a hard transition for family to make. You've got patterns set up of
sure.
keeping this amazing person safe for years and years and years. It's a lot to ask to go to a mom and say, hey, they're ready, right? We're
Sure.
dating, we're going out, we're driving cars, whatever it is that we're doing. That's can be terrifying for a family. And again, a really great role for a corporate guardian to give that space. There's some healthy conflict there, in conversations we have between families of people we support and us as the final decision maker. Um, but yeah, that's living, and that's what we want for every one of them.
It is. It really, really is. It's the ultimate goal. Okay, so as we're wrapping up here, can you think of a scenario, a story, in all of your years working with us and working with folks in guardianship where somebody has had their rights restored and how it can possibly look? I'd love to give families something to strive for, something to look at as a that their child or loved one also can get there.
This is my favorite topic, so you'll have to tell me when I need to wrap it up. But yes, as I came into the ARC, the first year I entered a culture of rights restoration. The person who was working in my position before me had already set me up with a guardianship that was happening. And 12 years later, this gentleman got restored. His mom actually ended up being supported by us. And now this gentleman is our natural support, right? He used to be
Wow.
supported. Now he is support for his mother. And we hope that we keep heading in the same trajectory with mom too. Um, I would say in my 12 years, I've experienced 14, I think, restorations or successor guardianships. And they're always so satisfying. Of course, there's some fear with them and some liability with the clerk, right? So you really have to present a good case because they're not going to say, yes, go do whatever you would like if that is going to land somebody in danger. So you do have to bring a good case to the clerk, which reminds me of a young lady that I worked with in the central part of the state, and she was adamant that she would have her rights restored. She was challenged by some significant mental health challenges, and there was a lot to navigate, but she initiated the process, which is important. The clerks are going to want to see the writing or the words or the thoughts of the person who is coming to ask that their rights be restored. And she did a great job with that. We had a tough clerk who was not comfortable with this and ended up having 5 guardianship hearings. She ended up being asked to do a multidisciplinary evaluation, which is costly, and she paid for that herself.
Wow.
By the time we're to our 5th hearing, there was honestly no way for the clerk to say no. She had proven herself over and over. That is an outlier. It's not normally that many hearings, but it is not uncommon to have multiple hearings. So I would say to a person who is going to seek either limited guardianship or restoration that they plan to get either a no the first time or a come back in 3 months and tell me how this has changed, or come back in 6 months and how these adjustments worked. That's common. Those are common desires that clerks have to help them feel better about the decision that they have to make. So when you're in the conference room with the hearing officer just keep in mind that they're people too, right? And their decisions are going to be subjective and they're going to be considering everything about body language and how the involved parties feel and respond, but mainly about how that supported person brings evidence, how they present themselves, and that absolutely applies to if the clerk says no. If there's a strong and disrespectful reaction to that, you basically have no chance when you come back. So, the person maintaining that maturity and that centered, focused way of being in those hearings is very important because you are is ultimately up to that one person who is the hearing officer.
And I will assume that it is possible and hopeful for somebody not only with mental illness, but people with intellectual disability to also have their rights restored too. They don't have to have, above average IQ in order to meet some kind of standard for the clerk. They just have to demonstrate, right, the ability um, to make sound decisions, whether it's them themselves or utilizing some natural supports.
Absolutely. It's mostly about stability, safety, and is this going to be able to be sustained over time? And that kind of goes back to your point of the terminology incompetent really doesn't apply because clerks are looking for stability, security, and a good plan, a good future plan that the person's motivated about. And they now maybe have some new tools to achieve that.
Or maybe health and financial stability can be the new word on the forms one day instead of
That'd be nice.
incompetent. Okay, well, thank you. I so appreciate you joining me today. I will make sure that we want to give families or individuals information about how to get to us if they want more information. So we will have that both in the video version of this podcast as well as up on our website. And I look forward to more conversations with you about this topic very soon.
Me too, Melinda. Thank you.
All right. Thanks so much, Kevin.